So I have with me today a very special guest, Professor Alex Pearl from University of Oklahoma, who is perfect to talk to about McGirt versus Oklahoma because he's an expert in Indian law and property law and water law. So I figure who better to go to than Professor Pearl. So thank you for being here.
I'm happy to be here. Thanks for inviting me.
So I've got, one of the things I talked about in the earlier video is that, I have knowledge of federal criminal law and some of the related topics, but there were some of the concepts in McGirt that were outside my sphere of knowledge, a little bit over my head. And I wanted to kind of start with some very basic notions. One of which is, when you read these statutes, the Major Crimes Act, and then before that, the General Crimes Act, the opinion, it talks about this concept of Indian country. And, that's not the way I'm used to hearing about it. I'm used to hearing about Indian reservations. Indian country is not a typical term that I hear. What is that concept and where does that come from?
So Indian country is both a legal term of art, a statutory term, and it's also become the colloquial way that indigenous people in the United States refer to our communities. So Indian country has become this sort of catch-all term, both popularly and legally, to describe the various legal permutations of lands owned by Indians, right? So Indian country legally comes from 1151, section 1151, 18 USC 1151, and it defines what Indian country includes. So like you said, of course, this includes what we call reservation land. So reservation land are lands that have been within the tribe's jurisdiction, or lands that they were traded for, where they signed a treaty, right? So a treaty is where a tribal government, tribal nation will confer their property rights to the United States and reserve for themselves some portion of that or Aboriginal homeland, right? So reservations, this is sort of like my first PSA of the interview here, is that when we think about reservations, the word reservation means exactly what it says, and it's land that was the tribe's and they reserved it, right? So a lot of times I think mainstream Americans think of reservations as places that have been given to Indians, and that's exactly the opposite, right? Now, within the term reservation, you could sort of understand American history by looking at the shifting federal policy approaches towards Indians over the course of our country's history. After the removal period in the 1830s, ushered in by Andrew Jackson, you had what we call the Allotment Period. So this is where you have tribes that have reservations, right? They've entered into treaties and they have a reserved land base that's communally owned by the tribal government. The federal policy then became allotment. The idea behind allotment is that you carve up all of these reservations, right, in big community ownership, and you parcel them out individually to individual Indians, right? So the idea was that if we confer private property rights and the good old American Protestant work ethic upon Native people, then they would be converted into United States citizens and, be happy white people just like the rest of the country, right? So allotment was an attempt to break down these tribal structures in the favor of private property ownership. So 1151 talks about allotments as well. So now, through various historical instances, you can have individual Indian allotments that are no longer within the reservation's boundaries, right? So this happens frequently with land transactions. tribal loss of land. So you can have circumstances where you'll have an allotment here that's really disassociated from the rest of the Aboriginal reservation, and then you'll have the reservation elsewhere, right? So there are lots of Indian country legally can be reservations, allotments, and then what we call dependent Indian communities. And this comes from a case called Sandoval in the 1920s from the Supreme Court. So there are lots of ways to think about Indian country, and there isn't just one narrow definition for it's always reservation land or it's always allotment land. There's, I think if you were to characterize it in some way, generally, it would be land ownership where there is some restriction or limitation that is federal in nature.
So Indian country, would it be fair to say that's the broadest, most general term that encompasses the other sub-concepts?
Absolutely. Indian country is, I think we're living in this moment in the country where we're not sure what terms to use when we talk about people or we talk about things, but Indian country is really the term to use that indicates a broad recognition of tribal communities and land ownership types.
Now, the particular piece of land or the particular part of Indian country at issue in McGirt versus Oklahoma is the Creek Reservation. Tell us about that. I've looked at a map of eastern Oklahoma, and when I see the map of Indian country there, it's broken down into a bunch of subunits. Is the Creek Reservation just one of those, or is it the broader piece? What are we looking at here?
Well, so within a given tribal reservation, whether it's Muskogee Creek or anybody else in the country, you can have individual land ownership that is private fee in nature, right? So you could have within the tribal reservation, you have restricted status land, you have an allotment, right, that is still owned by a native person, or you could have private fee land, right, that has passed out of restricted fee status and has been sold to a non-Indian person, right? So within the boundaries of the reservation, there can be lots of different types of ownership, both in terms of property status, but in terms of who owns them and whether or not they're a tribal citizen. Now, Eastern Oklahoma is unique because these 5 tribal reservations all have a very common history. As Justice Gorsuch pointed out, these lands all lay on the far end of the Trail of Tears, the removal period in the 1830s. Now, I am a citizen of the Chickasaw Nation of Oklahoma, and we are one of those 5 tribes. And so for so long, the narrative about the 5 tribes in Oklahoma, the Cherokee, Choctaw, Creek, Seminole, and Chickasaw, has been, we have Indian country, but we don't have reservations, right? Because those reservation boundaries are no longer in existence. What we know from McGirt is that with specifically to the Creek Nation, their reservation boundaries are still intact and have not been diminished for the reasons that he described. Now, there are lots of non-Indians that live there right now. There are lots of different types of fee ownership status there right now. There are probably state interests that exist there right now. And so I think that's where people are confused, concerned, nervous, happy, a whole range of emotions, given how you feel about living on a reservation. That has really created the concern here. So when you think about a tribe's reservation, think about that as the borders that which define the metes and bounds of the fullest possible scope of the tribal government's regulatory, adjudicatory jurisdiction.
I want to talk about the opinion itself. As I understand it, this is a case that was argued last term. The court didn't reach a decision. Presumably, I guess the inference that one could draw is that it was a 4-4 split, and Justice Gorsuch had recused himself. It was re-argued this term. Why did Justice Gorsuch feel comfortable weighing in on it this time, or was it a different case?
Well, this was a different case. So
Okay.
This McGirt and Carpenter versus Murphy, I believe, is the case style for the previous case. He had to recuse from because he took part in the opinion at the 10th Circuit. So he was able to participate in McGirt. And I think you're exactly right. That's everyone's suspicion, is that the court was deadlocked 4-4, and they understood that Gorsuch would necessarily break the vote. And so I think that's exactly why McGirt has the posture that it has.
And there was a companion case here. I know in my description, I kind of collapsed the two cases into one, talked about the Oklahoma Supreme Court case and then the 10th Circuit case. You clerked for the 10th Circuit, and, what insights do you have there? How does the 10th Circuit obviously ruled in favor of the tribes, or I guess in favor of their land in this case, or the recognition of their land? Was that any surprise to you, having worked with some of those judges?
It wasn't. So I clerked for the Honorable William J. Holloway Jr., who's passed. He's actually, the federal building is named for him in Oklahoma City. He was a lovely man. The 10th Circuit occupies or sits in Oklahoma and New Mexico and Colorado and Utah. So it has a significant swatch of Indian country within its boundaries. And so every justice on the 10th Circuit will necessarily be more familiar with Indian law, Indian country issues, certainly criminal jurisdictional issues like those brought about by the Major Crimes Act. So I think when as a former private attorney, when you're thinking about where to file a case, if you've got an option to test an issue with a tribal community in the 10th Circuit versus someplace in New York State, right, Second Circuit, when you compare those two circuits and their history of rulings with regard to Indians, they couldn't be more different. The 10th Circuit really, I think, you can throw out the left, right, conservative, liberal monikers for judges there, because it just doesn't map on to Indian law precepts. So I think that, as you can see with Justice Gorsuch, the 10th Circuit understands Indian country, is more familiar with it and those principles, and I think they will be more reliably consistent with longstanding Supreme Court precedent.
Well, and I think that's consistent. What you just described is consistent with what Justice Gorsuch did in this case, siding with the traditional liberal wing of the court, although, it doesn't always break down the way we think it does.
Right. So I think a lot of the mainstream media in response to McGirt has said, oh, look at Justice Gorsuch siding with the liberal wing of the court. For those folks that follow Indian law, understand Justice Gorsuch, are aware of the 10th Circuit, we were worried about Justice Ginsburg. Justice Ginsburg has written a number of very unfavorable opinions regarding Indian country and tribal governments, tribal sovereignty. So I think for folks that were following this case closely, Justice Ginsburg was the one that everyone was really worried about. I personally thought that this would go our way, the tribe's way, if we see Gorsuch write the opinion. I think there's so much from this opinion to sort of discuss and describe and get through.
Well, I want to ask about that.
Yeah,
one of the striking things about the opinion is how it begins. It begins talking about the Trail of Tears. In my discussion, I began with something much less interesting, the General Crimes Act. What is the significance of the Trail of Tears for this case? And do you think that's an appropriate starting point to tell the story of this case?
Yeah, so I'll be honest, as a scholar and a former advocate for Indian country, and as a Chickasaw person with Chickasaw kids, every time I read that first paragraph, it brings tears to my eyes. It really does. And so I think that there's a way lawyers are taught to be divorced and dispassionate and coldly analytical. I can't be that with this introductory paragraph. I think it is among the most beautifully written paragraphs in Supreme Court history. Justice Gorsuch, I think, is known as being a very skilled craftsman with his prose. And this first paragraph is no different. So I have a very strong connection to starting the opinion that way. Starting with the Trail of Tears, I think as a Native person, we are so used to our story, our history, not being part of federal common law or the federal narrative or the American narrative, right? We are so often invisible, and people have a sense of what the Trail of Tears was, perhaps, but that moment, that event is so significantly defining for my community and for the other 4 tribal communities that were removed in the 1830s. And every Native lawyer that I've spoken to that is from one of the 5 tribes has had exactly the same reaction. Tears, and just sort of this release of a federal Supreme Court opinion is acknowledging our history. And that is incredibly meaningful because it's so rare. Let me just give you one contrast to this. In a really critical Indian law opinion called Adoptive Couple versus Baby Girl, I think this is 2016, this dealt with a very difficult Indian Child Welfare Act case where ultimately one of the questions was, who does this Native child, is this a Native child? And if they are a Native child, then how does that affect her adoptive status, right? And Justice Alito wrote that opinion, and among one of the first lines in his opinion was, this case involves a child who is 256th Cherokee, right? And so the problem with that, and I don't want to get too far afield here, but this really draws the point home, is that Native people, in my experience, we don't think of ourselves as fractions and blood quantum. We think of ourselves as either belonging to a community, connecting to that community, culturally relevant to that community, rather than how much Indian are you, right? That's not a thing that Indians say to each other. That's a thing that folks who don't know any better say or ask Native people. So to contrast Justice Alito's characterization as a Native child as a fraction versus Justice Gorsuch starting with among the most significant moments in these 5 tribes' histories shows you how hard it is in the Supreme Court for tribal interests to succeed. So I think the larger context here and the fact that Justice Gorsuch begins that way is absolutely essential.
One of the things that accompanied the Trail of Tears was a promise made by the United States to these tribal groups that they would have a home in this part of the country. The promise was made, as I understand it, in the form of treaties.
Right.
One of the things that really stuck out to me, not knowing anything about this area of the law, particularly when we get to treaties, is that it's perfectly acceptable legally for Congress to walk back their treaty obligations so long as they've spoken clearly when they do so. And it seems like this whole case turned on the simple question of, has Congress clearly withdrawn its treaty obligations here? Is it really that cynical? Is that really what the crux of the case was?
Yeah, so very good point. Good question. The idea that the United States may unilaterally abrogate Indian treaties comes from a case called Lone Wolf versus Hitchcock, 1913. And when I teach federal Indian law, it's usually at this point where the students in the class think, are you serious? You mean we can make this agreement, sign it, ratify it, and then Congress can just change it, even if the treaty says any modification to this agreement must be approved by some percentage or fraction of the tribal members, right? Congress can ignore that, pass another statute, and just impose it unilaterally on the community, right? So it really is that simple. And so when I referred to those allotment acts earlier, that's an example, right, of Congress saying, we're going to carve up your reservation, parcel it out to individual Indians, and then, oh, look, we have some leftover land that you don't have enough members for. We're going to sell that to, we're going to patent that out to railroad companies, land grant universities, the highest bidder, whomever, right? So the difference for Gorsuch is, did the Allotment Act specifically say that the Creek Reservation boundaries are hereby disestablished, right? And that's really what it comes down to. And, you know, we sort of avoid the lone wolf versus Hitchcock question of like, is that even good law? Is that even feasible? Can that happen really? And Gorsuch just applies a very textualist approach, right? Now, typically in these cases where, you know, courts are asked to evaluate whether the reservation boundaries for a tribal community have been disestablished, this is the Solemn v. Bartlett test. So usually it has three major factors. The first factor is, what is the language in the statute that purports to disestablish the reservation boundaries? How clear is it? Is there this sort of like magic language that courts usually look for? And if that's ambiguous, then the court is able to go and look at like, okay, well, what are the demographics of the region, right? How many white people live there as compared to native people? Well, what was Congress's expectations of how that land would be used? What were the tribe's expectations about how the land would be used? So I think, and this is just my view as a scholar and somebody that's written about Gorsuch and has written about these reservation disestablishment cases, is Gorsuch really dislikes that test. I think he thinks that going beyond the text is reaching for a reason to disestablish the reservation, right? And I think what he has done is he's really held Congress's feet to the fire and saying, look, he's really, I would argue that he's essentially collapsed the Solemn v. Bartlett three or four factor test into one factor, essentially a textualist factor. What's it say? If it doesn't say that it disestablishes with any clarity, then it's not disestablished and we're all going to go home, right? So I think, and this is something that really tips the scales in favor of tribes, but properly so, not in any sort of like public policy method, but like the question is, what does the statute say? If it doesn't say that the reservation's disestablished, then it continues on. Because what the other factors have done historically is they allow Congress to not clearly say we're destroying this reservation, but instead they just allow the reservation to be de facto destroyed by having non-Indians come and populate the former reservation, right? And then, lo and behold, when the courts get this question and they say, well, they look at the demographics, right? And they say, well, how can this still be a reservation that's Indian in nature when 70% of the people living within its boundaries are non-native, right? So it's sort of this self-fulfilling prophecy. And Gorsuch rejects the idea that we should really look at those other factors and give them much weight at all in terms of evaluating whether or not the reservation boundaries are still intact.
Having not read the cases that you just described, you know, it's curious to me that when you have a factors test, here you have such a strong reliance interest by the tribes on this treaty agreement. Why doesn't that override all of the other factors? I mean, these are people that have, for generations, have depended upon this treaty. Why doesn't that override? Is there a discussion of that in these cases?
There's not usually. I think usually those reliance interests end up getting coupled up with the terms of the treaty, and then it just is subject to lone wolf, right? And it's like, well, Congress just believes differently, and so you lose. Now, I think there's that to sort of say about it. I think just to play devil's advocate on the other side, Oklahoma would argue, well, look, we have reliance interests because we have always understood this to not be reservation land. We've policed it like not reservation land. We've charged people like not reservation land. So where's our reliance interests, right? And I think that there's something to be said for that. But, you know, that goes to Justice Ginsburg's line of questioning and during the oral argument, which, you know, because of coronavirus, we were all able to hear, which was sort of fantastic. But she was very focused on what are the ramifications of this? What's going to happen to, you know, the police force in Tulsa, Oklahoma? how is this going to affect Shawnee or Okmulgee or Muskogee or all the other little towns in eastern Oklahoma? And how does this, and what is the Creek Nation going to do? Does Choctaw and Creek and Chickasaw and Seminole, do they all have the current capabilities for law enforcement to adequately police those areas? I think those are the sort of very real practical concerns that are not necessarily determinative of the outcome here, right? But there's certainly things that the parties have to figure out now on a go forward basis.
So another way of looking at this case is it's simply a question of jurisdiction, particularly in the McGirt versus Oklahoma opinion. You know, who can prosecute Jim C. McGirt, right? That's a basic question. You have state authority that did prosecute him 3 times, and then you have tribal courts, and then you have federal court. What is the motivation for Oklahoma to want to have jurisdiction over this area in terms of crimes? And what is the motivation of the tribal authorities to want to maintain their own affairs? I'm sure there's a whole history of this.
Yeah, I mean, so it's a fantastic question, and it's one that it's a continuing conversation. It's a relationship between the state of Oklahoma and the various tribes that are located within Oklahoma's boundaries. Now, I think for Oklahoma, the concern here is, can we adequately protect and serve the non-Indian communities living within now reservation boundaries, right? So there you have citizens of cities that have never thought of themselves as living on a reservation, have never been subject to reservation police authority or criminal jurisdiction purposes. And now the question is, well, if state law doesn't apply on the reservation, how are we to conduct ourselves, right? And, you know, in the context of criminal jurisdiction in Indian country, you know, I think every Indian law scholar, student, advocate, every AUSA probably somewhere in their lives has had a chart, right? Mm-hmm. Of like, if the perpetrator is native and the victim is native, who has jurisdiction, right? If the perpetrator is non-native, so on and so forth. And that ends up being very, very complicated. Now, so I think there are some concerns here from non-Indian cities that go towards, you know, can we adequately protect and serve non-native people within a reservation if we don't have any jurisdiction there. I think for tribes, criminal jurisdiction is a very complicated issue. One, there is this history of states and tribes being at loggerheads, right? And being, one Supreme Court opinion has called them the deadliest of enemies, right? So there's this inherent tension oftentimes between states and tribes. The state of Oklahoma is a little bit different because there are 39 tribal communities within the state, and the tribes play such a critical role economically in the state that Oklahoma can't really sort of push tribes around. And the Oklahoma tribes have been pretty good about being connected and allied together and advocating for certain issues before the state. But in the context of criminal jurisdiction, tribes want to be able to police themselves. They want to protect their members. They want to make sure that their people are safe. It's the mirror image of what the state of Oklahoma wants. So given this history of distrust between tribal communities and state communities, that's part of what gives rise to the concern. But ultimately, tribes want to manage their own affairs. Now, money comes into this question, right? Of if my tribe's boundaries, right, that we are legally responsible to police, have now expanded, you know, 5-fold. Well, I don't know that we have the funds necessary to sort of do that effectively. And I don't even if we do have the funds, that will be a political question as to whether our government, the Chickasaw Nation government, sees that as a worthy expenditure if we can contract with, you know, McLean County or some other county and have them do it for us, right? So I think that's the rub here, is that the jurisdiction is a part of being a self-governing, self-dependent, you know, community that governs itself. The drawback is that can be expensive if we're not absolutely certain that that is how we want to use our sovereignty.
So, on the most granular level, or from the most granular perspective, what we know from McGirt versus Oklahoma is that Mr. McGirt is going to have to be retried for his crimes, maybe in federal court, maybe in tribal courts, but certainly not state courts. Then, when you pull up the headlines on New York Times or CNN.com, what you know is now all of eastern Oklahoma, or almost all of it, is Indian country. Taking those two things, what I don't know, or what are the broader implications of this holding? Does it answer other questions, or can you point us in any direction here?
So what's interesting about the term Indian country defined in 18 USC 1151, which is the criminal title code, right, is that that term Indian country in our way of conceptualizing it is just imported into the civil context. Okay, so what this has equal ramifications for civil jurisdiction is in Indian country, just as it does criminal jurisdiction. And now the civil jurisdiction case law is fraught, unclear, fractured, and ambiguous. Now, so I think that makes everybody more concerned. So let me give you a very clear example. I referred earlier to the Indian Child Welfare Act, which is a federal statute that purports to provide tribes and Native parents with certain rights when it comes to the adoption or other custodial proceedings of Native American children, okay? One of the provisions in that statute allows for tribes to exercise exclusive jurisdiction over the custodial hearings or child adoption fostering hearings of their Native children, okay? Now, and it has to occur within, if they are domiciled within the reservation, right? So you see immediately where this ruling and defining the Creek Nation as an intact reservation will have a huge impact on the extent of the Creek Nation and the other 5 tribes' national boundaries for purposes of exercising Indian Child Welfare Act jurisdiction, right? So you'll see it there within the civil context with Indian Child Welfare Act. You'll see it in whether or not tribes can regulate oil and gas operations, right? If now within a tribe's reservation, the tribe can say, I know that you're on private fee land, but that's within our reservation boundaries. And so you are subject to our regulations, not the state of Oklahoma's. And so I think that's another area where you could see tribes trying to regulate non-Indians outside the criminal context. And I think those are the areas where people are most sort of like concerned on a going-forward basis.
I know like Texas has the Texas Railroad Commission that regulates oil and gas interests. I'm sure Oklahoma has something essentially the same. Do tribes have a regulatory authority over oil and gas pipelines, something like that?
Yeah, so it's a great question. And it's going to depend on tribe by tribe. There's just shy of 600 tribes in the United States, 39 in Oklahoma. And so, some tribes, and a lot of times it's dependent upon their own priorities politically or their own, financial, ability to create departments. But, there are tribes in northern California that have departments of natural resources, departments of fisheries, departments of water quality. And those people and those tribes employ scientists and other policymakers to ensure that those resources are taken care of within the tribe's boundaries. Other tribes, they don't have those circumstances, or they don't have that ability. So tribes absolutely have the ability to regulate things within their boundaries, especially when it comes to oil and gas. They have the ability to forbid it on tribal lands within their reservation. Now, that ends up being part of the question of, well, under what circumstances does federal law allow tribes to regulate non-Indian conduct on their reservation? Even if the tribe says, we're regulating your conduct, there's a whole hornet's nest of case law that evaluates that question. But prior to McGirt, the five tribes couldn't even make the argument because
Mhm.
no one thought of it as reservation land or Indian country.
Well, I'll be curious to see, how much Supreme Court litigation we see coming out of the 10th Circuit, out of the Oklahoma Supreme Court in the wake of McGirt. And before we go, if you have any comment on that, I'll give you the last word.
I think on a go for it, just today, the five tribes in the state put out a statement that I think has been talked about a little bit in Indian country media, that indicates that they're trying to work out how to share jurisdiction, both civilly and criminally. Who's going to play what role, who's going to do what, who's going to pay for what. And it's one of those things where you're not going to please everybody. And I think that it's going to be really interesting. I think we will definitely see legislation. I think we'll 100% see legislation that will help answer some of the questions that we've talked here today. I think that, we'll see how tribes prioritize the value of asserting their own criminal jurisdiction to the fullest extent of their reservation borders. That may end up not being very important to some of our tribal communities. But that is a political question. And the hard part for tribal communities right now is, as we've discussed, Congress can pass a statute and just overturn McGirt, change it, overturn the treaties, do whatever they want, right? And we don't have a way to say no to that other than to hire better lobbyists, right? So that's the battle now, is what's going to happen in Congress. What's the legislation look like that helps to resolve this sort of like simmering uncertainty that everyone's concerned about. So I think there will be some pressure on the five tribes specifically to sort of hang together on this, and that may be tough to do, but we'll have to sort of wait and see. But I would expect legislation to come pretty quickly to try and resolve some of these issues. That's where we got to go. I think before we get to the litigation stage, I think we'll have legislation before then.
Very interesting. And thank you so much for speaking with me today.
It's good to see you as always. Thank you.